Hi, welcome to Unit 8, Criminal Competency and Assessment. So today we're going to talk broadly about forensic psychology and then specifically two areas within forensic assessment, the assessment of competency and insanity for the insanity defense. So remember, forensic psychology typically refers to clinical psychology, someone who's trained and licensed to work directly with clients, which is different from social, cognitive, and developmental psychology, which typically are not licensed to work within clinical settings with clients. As we discussed earlier in the course, the testimony of the psychologist must meet Daubert standards such that it's sufficiently relevant and reliable for testimony to be allowed. It also must be right and not be overly prejudicial. The use of psychologists as experts has increased according to recent surveys. Forensic psychologists are used at all stages of the criminal proceedings, not just at trial. The book mostly focuses on court proceedings, but keep in mind there are other areas, and in the next unit we'll talk specifically about assessments within a civil context. So these are just some examples of where psychologists may perform assessments. Remember, today we're going to be talking about the areas within criminal law, such as competency, insanity, and then your book talks about sentencing. And then, again, Unit 9 will focus on some of these civil areas. So often, competency and insanity are confused. We're going to be talking about both of them today, so hopefully some of those confusions will be settled. Competency involves the defendant's present state of mind at the time of the proceedings, whereas insanity looks at the defendant's state of mind at the time of the crime. So the biggest distinction between competency and insanity, even though they both look at the mental state of the defendant, is really the timing of when it occurs. In order to be competent, they must be competent right now in order to proceed through legal proceedings, whereas insanity talks about their mental state at the time of the crime. There are different standards for both competency and insanity, and we will discuss each one of those more in detail. So just a general overview about the differences between competency and insanity. Keep in mind that the words competency and insanity are legal terms. So even though they have psychological connotations, competency and insanity actually are definitions that are actual legal definitions, where psychologists come in and offer evidence to either support or not support the legal definitions. Competency, there are several different kinds, and the standard really depends on the type of ability that's required for that particular activity. So, standing trial, pleading guilty, waiving Miranda rights. Competency is assessed differently within each of those contexts, and the person must demonstrate competent abilities within each of those specific contexts. Insanity, on the other hand, the standards differ by jurisdiction, depending on what the jurisdiction chooses to adopt. But they all the standards rely on the same idea, that the person should be insane at the time of the crime. Within competency, psychologists will assess whether or not the person has the capacity or ability to perform that activity. And in insanity, the role of the psychologist is to assess the person's state of mind at the time of the crime, which of course has some difficulties that we'll talk about in a little while. But first we're going to start off with competency. So adjudication is a decision made by a judge. So when you see the word adjudicated competent, it's that the judge has made a decision whether or not that person should be deemed competent, based on evidence that a mental health professional will provide. So typically a mental health professional will interview the person, maybe give them some assessments or some survey tools, and present the evidence to the court, and the judge will then decide whether or not the person is competent, not the mental health professional. The person must be seriously deficient in one or more abilities, and as I said earlier, that will depend on the specific legal proceeding at issue. And again, I'll talk about each one of these competencies in order because there are several. So why do we require competency? There's three main reasons that your book talks about. First, as an American legal system, we really want defendants to understand the legal proceedings in front of them. By understanding them, they have an ability to assist and recognize that that will lead to more fair and accurate outcomes. The second falls under the theories of punishment. So we find that punishment is really only acceptable if a person understands the reasons that they're being punished. And the third is really for the integrity of the justice system. We want defendants to have the capacity to defend themselves because it really doesn't lend itself to fairness if the person can't formulate a proper defense. So the first type of competency is competency to plead guilty. When a person is pleading guilty, they're waiving several of their constitutional rights. The right to a jury trial, the right to confront their accuser, the right to call favorable witnesses, and the right to remain silent. Judges are required to inquire into a defendant's plea to make sure they understand that they're waiving all of these rights. And the standard is that they must knowingly, intelligently, and voluntarily waive these rights. So this means that knowing what the possible penalties are, and they must be able to examine plea bargains to make sure that they're voluntary and that the person is considering their different constitutional alternatives. So the key in being able to plead guilty is to be able to understand what the different options are. If you're pleading guilty, it means that you may have a certain sentence, whereas if you don't plead guilty, you'll go on to trial. So we must make sure that people understand what rights they're giving up before we allow them to competently plead guilty. The second type of competency is the competency to stand trial, which is probably the one that you hear about the most and is what's first talked about in your book. So all states have some variation of what's been called the Dusky Standard. They have some minor differences, but the Dusky Standard is what guides whether or not somebody will be adjudicated competent to stand trial. The standard says that the person must have the ability to consult, rationally understand, and factually understand. So they need to have the ability to consult with their attorney in order to come up with proper defenses and to discuss different alternatives. And they have to rationally and factually understand what's going on. Again, this refers to their present ability to stand trial. So if the person did not demonstrate competency earlier but does during trial proceedings, then competency may be at issue then. The Dusky Standard does not say how evaluators should judge each of these factors, but information will be presented that's either consistent or inconsistent with each of these factors, and then the judge will then decide if the person is competent to stand trial. The Godinez case basically said that the competency to stand trial standard will be used for all competency types. So, like the competency to plead guilty in the earlier slide that I talked about, the Dusky Standard would then apply to all of these cases. So even though the legal system recognizes that competency is different across all these different domains, the standard still remains the same. Another type of competency is the competency to waive one's rights and defense. So the Gideon case says that criminal defendants have the right to counsel for crimes that would likely lead into incarceration. So usually not misdemeanors, but Ferretta said that this right can be waived if somebody would rather represent themselves than have an attorney present. The judge actually makes this decision of whether or not the person is freely and intelligently refusing their right to counsel. And this is an area where psychology is not actually involved, but really the decision falls under the judge. But it does beg some questions, like whether or not the defendant needs legal training, how much experience they have with the legal system. One of the famous examples of somebody who represented themselves was Ted Bundy, who was a famous serial killer from 80s and 90s. He was very well spoken and was actually complimented on his ability to represent himself. But during the court proceedings, he had several angry outbursts, so it begs the question of what kind of impact it might have when a defendant represents himself. The second type of capacity is the capacity to waive one's Miranda rights. So a waiver of Miranda requires a person to waive their rights to self-incrimination before confession or to have an attorney present while in police custody. This is a difficult area for psychologists to assess because the confession usually has already happened and the defendant may be arguing that they didn't have the competency to waive their Miranda rights before they actually waived them. But psychological research has examined this to see under what conditions people are competently able to do this. And then the last one I wanted to talk about is competency to refuse the insanity defense. So courts are really divided about whether or not one should be able to refuse the insanity defense. Most take on the framework very similar to competency to plead guilty, but other courts require that the defense is used when a person is mentally ill. Probably the most famous example of a refusal to use the insanity defense is Ted Kaczynski's case. He's the Unabomber, and he actually refused to use the insanity defense against the suggestion of his attorneys because even though he was diagnosed paranoid schizophrenia, he didn't want to be labeled as a sickie by using the defense. Alright, another type of capacity is the capacity to be punished, and this really falls under two frameworks, whether somebody has the capacity to be sentenced and the capacity to be executed. So similar behind the rationale behind not punishing an infant, for example, who misbehaves, the legal system really doesn't think it's fair to punish people who don't understand the punishment or why they're being punished. The rationale for needing competency to be executed falls under the 8th Amendment of the Constitution, which bans cruel and unusual punishment. This is basically the same amendment that says certain types of executions are cruel, like using a firing range. But if you recall, from the very first unit, constitutional amendments are interpreted through case law. So the case that interpreted the 8th Amendment as applying to capacity to be executed is a Ford v. Wainwright case. In this case, the defendant was convicted of murder, and there was really no issue of competency until the time of his execution. At that time, they conducted several assessments by several different psychologists. Ultimately, the Supreme Court held that executing incompetent people really has questionable retributive power and general to deterrence, and the court said that it basically offends humanity. So in evaluating whether or not a defendant is competent, there are several assessment tools, structured tests, and questionnaires that clinicians use to make this judgment. So remember earlier I said that clinicians will typically interview the defendant and then offer evidence based on that interview, and then the judge ultimately makes the decision of whether or not the person should be adjudicated incompetent. So just having a mental illness, remember, is not enough. But the question is really whether that illness impairs the cognitive process required for that particular activities. So the tests will vary on how this is determined. Some of them give short vignettes and ask the defendant to answer questions, whereas others are more of a semi-structured interview. Of the percentage of people that are referred for competency evaluations, about 70% are found competent. So even though somebody is referred to have these assessments, it doesn't necessarily mean that they will be adjudicated incompetent. Often when they are adjudicated incompetent, they don't just walk out and go free. Typically they're reassessed at periodical intervals to see if they have been restored to competency, because the ultimate goal when somebody is adjudicated incompetent is to return them to competency so that they may proceed through the legal case. And finally, if somebody is adjudicated incompetent, they won't be held indefinitely. The court has said that we cannot keep people longer than is a reasonable time if they're found incompetent. And this will generally be weighed against what kind of crime they've committed and how long their incarceration would have been had they gone through trial. Okay, so moving from competency to the insanity defense. The insanity defense basically allows for a defendant to claim they didn't comprehend the consequences of their actions. Remember, this is at the time of the offense, so it doesn't matter how mentally ill they are at the time of the trial. What really matters is what their mental state was at the time of the crime. Of course, because we are looking at their mental state at the time of the crime, there are many challenges in order that we face with finding out that truth. So it's really hard to know what was happening in the mind of the criminal defendant at the time of the crime, because we're doing this retroactively. Sometimes it could have been years since the crime had been committed. So the forensic psychologists or clinicians have to gather evidence about what was going on in that person's life at that time in order to make that type of assessment. There are fewer assessment tools to assess insanity than there are for competency. And legal ideas of insanity are different than in psychology. So in the legal system, remember, legal professionals want a yes or no answer, was he insane or not? Whereas psychologists are not so inclined to give such absolute decisions, but would rather discuss things more on a spectrum. Okay, so some famous, notorious insanity defense cases. All of these cases have very bizarre facts, and all of these cases use the insanity defense. What I'm going to do is just describe each one of these cases very briefly, and just think to yourself whether or not you think the insanity defense was successful in that particular case. So the first one up is Ed Gein. He's actually the inspiration for the movie Silence of the Lambs and the Texas Chainsaw Massacre. He was a grave robber who took skin from victims and wore it. Does that sound insane? Do you think it was successful? Yes. The courts deemed him legally insane, and he actually lived out the rest of his life in a mental institution. The second person on the list is Jeffrey Dahmer. Jeffrey Dahmer was a notorious serial killer and sex offender in the early 90s. His list of offenses included sex, cannibalism, so eating other humans, necrophilia, having sex with dead bodies, and dismemberment. Since he was a child, he'd shown symptoms of withdrawal and avoidance in social interactions. He would collect dead animals, then dissect, dissolve, or mutilate them in various ways. So I ask you, was he insane? The court said no. Actually, he was convicted and given 15 life sentences. The court said that he knew what he did was wrong, as evidenced by the way that he tried to cover up his crimes. The third one on the list is John Wayne Gacy. He killed 33 young boys and men in Chicago and buried them in a crawl space in which he dug out. The discovery of his murders and subsequent arrest shook the community, as he was known for his active involvement with local projects and his volunteer work as a clown. Was he insane? The court said no. He was sentenced to death. The court said that due to his extensive measures that Gacy took to avoid detection, including ordering his own construction company to dig the crawl space, which he claimed to be a drainage trench. The fourth example, oh, I just gave it away. Bummer. The fourth example is Lorena Bobbitt, who we all know as the woman who cut off her husband's penis. She used the insanity defense as a result of domestic abuse, so she claimed that her husband had been abusing her, and this was her retribution for that abuse. She was found insane and underwent mental health treatment. What's interesting about her case is that she was actually released 45 days later, which is a common misconception with the insanity defense that I'll actually talk about on the next slide. And then finally, John Hinckley. He was obsessed with the movie Taxi Driver and Jodie Foster, who plays in that movie. He attempted to assassinate President Reagan. He was acquitted on all of his 13 charges due to the high-profile nature of the case because he attempted to assassinate the president. The public perceived the insanity defense as a loophole in the legal system, which allowed him, a clearly guilty criminal, to dodge incarceration. So basically, in this case, they did find him to be insane. And because of the controversy surrounding this case, and because people clearly saw him as being guilty and accountable for his crime, this brought about reforms of legislation because the public was just outraged that somebody could get off by using the insanity defense. So I think one of the biggest misconceptions about the insanity defense is that it's used all the time and it's a way for criminals to get off. But really, if you look at this pie chart, most cases result in plea bargains, so that's the light blue part. Very few cases actually go to trial, which is the dark blue part. And that very, very small sliver red line are the number of cases that actually raise the insanity defense. Now, I think that red line is even too big in comparison. I couldn't make a red line small enough. but it's less than 1% of the cases that go to trial that actually raise that defense. And of those 1%, only about 1/4 are actually successful. So really, the success of using these insanity defense is not all that common. Another misconception about the insanity defense is that once the person has successfully used the insanity defense, that they just walk out of the courtroom and go home. However, in some states, it's more likely that the person will remain in a mental institution far longer than they would have within a prison setting. Except, of course, the Lorena Bobbitt example that I used before. So the insanity defense is what we call an affirmative defense, which basically says, I did the crime, but I shouldn't be held responsible for it. The defendant must present the evidence to show that he wasn't responsible for the crime, so we say that the burden falls on the defendant in order to offer evidence. The rationale for the insanity defense primarily fall under the theories of punishment. We don't want to punish people who don't understand what they were doing was wrong, because one of the rationales is that people only really learn from their bad behavior if they understand why they're being punished for it. Again, the standards differ by jurisdiction, and it really is up to the states to choose which standard they'd like to adopt. So there's the book discusses two of the most common standards. I'm not going to go through each one of the first two, because I encourage you to read that in your book. But the book doesn't mention the second two. So the first one is the Monotone Rule, which is the most commonly used rule. 29 states in the federal government use the Monotone Rule. The Bronner Rule is used in 14 states, and the specific language of each of those is mentioned in your book. The two that are not mentioned in your book, the first is the irresistible impulse test. Basically, this is a prong that's been added in some states, the Monotone Rule, and it looks at whether or not the person acted with an uncontrollable impulse. So if the person has lost the power to choose between right and wrong such that their free agency is destroyed, or the defendant was somehow involuntarily acts beyond his or her control, this kind of gets at that volitional part of the standard. So a test that's often used is whether or not the person would have committed the crime had a police officer been standing right next to them. The second one is the Product Standard Durham Rule, which is only used in the state of New Hampshire. But basically it looks at whether or not the defendant is criminally responsible if the criminal act was a product of the mental disease or defect. Now, because there was so much public outrage about the insanity defense, and because there are these common misconceptions that it's used all the time or that people walk free, there have been recent reforms to try to improve the use of the insanity defense and to really narrowly tailor it to its intended audience, which are people who really are who do not understand the difference between right and wrong. So one of these alternatives has been to offer as an alternative to not guilty by reason of insanity is what we've called guilty but mentally ill. So with guilty but mentally ill, a jury or a judge can find the defendant guilty but mentally ill, which basically means that they have committed the crime, they are guilty, but there's a recognition by the court that the person is mentally ill. What this means is that they may be provided more treatment in prison, and it kind of acknowledges that the person may have not been as mentally culpable as somebody who's found guilty. But really, when you look at it practically, the person is still sentenced, and it's just that they may receive more treatment than they would have if they were found guilty. Another alternative has been to offer a plea of diminished capacity. So the diminished capacity recognizes that a person may have a mental illness that affected their mental state at the time of the crime. The idea is that they should be held somewhat responsible because they did it, but not completely so because their mental state, they didn't have as much intent with their mental state. The result of using this may be that they may have a lower sentence, or the actual crime may be reduced from, say, murder 1 to murder 2. And then the last revision or reform is to eliminate the insanity plea altogether. So some scholars say it's not just because that the insanity defense is not just because it places unfair burdens on juries, psychiatrists, and society, Whereas others say, you know, we really do need this. People that don't know if what they've done is wrong should have the opportunity to use the defense. So there isn't a lot of empirical research on these areas yet, but they are emerging areas of psychology and law. Okay, that's all we have for this unit. Thank you.